thank you everyone who has already joined the afternoon session of the development issue workshop. We have one of our presenters with us, but Professor Triantis, if it's okay with you, we'll give, and I'm now seeing that Professor Ellias has arrived. So after he gets his camera situated, I'm happy to turn it over to the both of you.
Great. Should I start, Matthew?
Yes, whenever you both are ready, we are ready for you.
Great, great. Well, thanks, Matthew, and thanks, Vera, for inviting us to not only to contribute a paper, but also to participate in the symposium. I wanted also to thank our panelist colleagues for their tremendously interesting papers and their presentations. It's an exceptionally high quality a group of papers for this symposium. Also wanted to thank the participants who have joined, and a special shout out to Bob Rasmussen, who like Tony and Joshua, we too owe an intellectual debt to him for an article, believe it or not, 3 decades ago that he wrote on bankruptcy in the administrative state. And it's actually a part of a launching point for our paper. So this is a joint paper with Jared Ellias, and we're going to split our introduction or our presentation here at this symposium. So the paper builds on 2 phenomena in business bankruptcies or commercial bankruptcies. The one is the ongoing tension between government regulation and bankruptcy law. And Laura Cordes talked a little bit about it with respect to the Postal Service, but it's been something that has been commented on a fair bit in the scholarship and in practitioner commentary for decades. The second is the rise of activism in bankruptcy, investor activism, and particularly for our purposes, the rise of activism for purposes other or motivated other than for the simple maximization of returns on claims. So the first building block for us, as I said, is this tension between government regulation and bankruptcy, whether the regulation is in the field of the environment, of labor, or communication. And in bankruptcy, government has been typically on the defensive. That is, that often the debtor is using the bankruptcy process, specifically the bankruptcy stay on enforcement of regulation, and the discharge to avoid liability for past violations, and even to avoid injunctions to correct past violations. That's been a part of the plan of the debtor in going into bankruptcy. And when the debtor can use bankruptcy to those ends, it undermines the deterrence of the regulatory provisions and the execution of regulatory goals. So in a very loose way, bankruptcy is sometimes a tool for regulatory avoidance. There are limits, of course, to the ability of the debtor to neutralize regulation. And in particular, the courts don't allow the debtors to act in such a way that poses a prospective danger to public health or to public safety. So the current filing of the National Rifle Association, the NRA in Texas, is a good example of regulatory avoidance. Perhaps it's bad venue shopping, to use Tony and Joshua's characterizations. And there are also defensive mechanisms taken by the New York Attorney General in order to allege bad faith and to have that bankruptcy filing dismissed. And so that's sort of a typical sort of game being played by the debtor and by the regulatory agency. As I said earlier, the second a building block for us is to note the rise of bankruptcy activism in the past couple of decades. And the tools that are well known for bankruptcy activism they include financing terms and debtor in possession financing that impose mileposts and deadlines and try to influence the course of bankruptcy of the commercial debtor. They may promote asset sales, And even apart from the DIP financing, the claim holder may have standing to bring objections or motions in front of the court to influence the path of the bankruptcy. If they have a large enough claim, they may have a veto position in the classes for voting purposes. And it's important to us that the motive of bankruptcy activism is not just to enhance the recovery of one's claim, but to promote, as some courts put it, ulterior objectives, ulterior financial objectives, such as gaining ownership of the reorganized debtor or being able to acquire some of its assets. And the rise of activism, as most people know in this symposium, has been met by guardrails that have been imposed by the courts, especially when they can exercise their discretion to pose those guardrails to control the use of the process for these ulterior motives. So one example is designating or disqualifying votes when the court notes these ulterior motives. So in the past decade or so, what Jared and I want to point out is that there has been a rise of government activism in bankruptcy, where the motive is not financial. It's not that the government seeks to maximize the return on its claim, but rather policy motivated or even politically motivated. We call it activist because it's not there simply to protect. It's not defensive simply to protect existing regulation against debtors' avoidance actions in bankruptcy, but it's actually levering bankruptcy to advance policy goals even beyond the existing regulation. So it's not news that government, particularly the executive branch, has a range of tools to advance its regulatory goals beyond the conventional notice and comment type of rulemaking. And so we know that governments use their procurement ability, their government contracting in order to promote regulatory goals. And there are also other creative avenues like deferred prosecution agreements or settlement of claims even outside of bankruptcy. But what we note is that governments are adding, and we project will continue to add, bankruptcy strategy to those avenues, in addition to the opportunities that present themselves when companies are in financial distress. And since the government's use of the bankruptcy tools are analogous to other forms of activism, that's why we call it government activism in bankruptcy. And just like investor activism, a key tool is debtor in possession financing or exit financing in bankruptcy. It's worth asking, and we want to return to this maybe in the Q&A period, that we know that governments can take advantage of the crisis of financial distress itself in order to be able to promote regulatory goals, to condition the bailout or rescue money on terms that promote those goals. And so an important question is, what more does the bankruptcy process add as a tool? And there are a variety of things that it adds, judicial authorization and blessing to changes such as sales of assets, and these sort of things are important. Bankruptcy can also blunt the impact of special interests that they might have in regulation. And we haven't really gotten into this very much in this paper, but I think it's worth exploring how special interest groups would operate in bankruptcy versus in the regulatory process. And there's certainly differences and advantages and disadvantages in the two fora. So we note, though, in making the case that bankruptcy provides added benefits beyond conditioning bailouts, that Chrysler and General Motors bankruptcies were largely the government's idea. It wasn't that Chrysler filed for bankruptcy and then the government seized on a strategy, on an activist strategy, but the idea of a bankruptcy was generated within the government process. So policy activism, just like investor activism, is not completely innocuous. And later, and Jared will talk about this, we'll mention why it might be an end run against democratic processes that would occur in legislative or regulatory lawmaking. But for now, what I'll note is that activism in bankruptcy and pursuing those goals come at a cost to other claim holders. And this type of redistribution in bankruptcy from existing claim holders, the redistribution of value from them to funding the pursuit of regulatory goals, fits in very well into the long-standing debate as to whether bankruptcy goals should be limited to wealth maximization, to fixing the collective action problem that interferes with the preservation of going concern value, or whether it is appropriate for pursuing other goals, redistributive goals, protecting workers, communities, jobs, things like that. The difference between what we're looking at with government activism and that debate as to what is the goal of bankruptcy is the involvement of the government executive. That under the debate over the last few decades, it was really a question as to whether the courts what are the goals that the bankruptcy court should pursue, whereas here there's a new actor, there's a government executive being involved in this. And when they are involved, I think there's an important question as to whether guardrails should be in place with respect to government activism, analogous to with respect to investor activism. So so that's the framework of the paper, and we look at two case studies. The one is probably extremely familiar to most people in this webinar, whereas the second one may be less. The one that's most familiar is the bankruptcy rescue of Chrysler and General Motors a decade ago during the Great Recession. And even though we're talking about Chrysler and GM on the one hand and Pacific Gas and Electric on the other hand, we want to acknowledge that there are undoubtedly many other cases. We know all the energy bankruptcies and the ones that are on the horizon in Texas, the Purdue Pharma case and so on. So this analysis could be applied to the government role in those bankruptcies as well. So acknowledging that the Chrysler and GM bankruptcy are relatively well known, let me just highlight a couple of points just to link it to government activism and what were the policy goals that the federal government, the Obama administration in particular, was trying to pursue. Certainly, the government thought it was important to keep Chrysler alive and to avoid the ripple effects that a Chrysler failure would have had on an already recessionary economy. Certainly, one of the goals was to improve the operational efficiency of Chrysler in doing so, so to use the financial distress to address the economic distress, to use the bankruptcy jargon. But the federal administration also did not waste the crisis to pursue, in order to take advantage of it, to pursue policy goals, other policy goals that are not sort of purely economic. So using its influence as a source of rescue funding primarily through the TARP money, the federal administration pursued two other key policy goals of the Obama administration. The one was promoting the shift to smaller, more fuel-efficient auto manufacturing and auto use for climate change policy reasons. And the second one is to protect workers in the midst of a recession. And so in providing the bailout financing, of course, it could have conditioned the bailout financing in a way that was consistent with the goals, but it was important to the Obama administration to also use the bankruptcy process. And as is well known, the way they did it is that the restructuring of Chrysler was framed as a bankruptcy sale under Section 363B to a new Chrysler that had new ownership. And this use of the sale provision rather than conventional reorganization plan has been subject to a lot of commentary. And as I said before, I don't want to review that, but as many of you know, Fiat received a 20% interest in Chrysler with an additional 15% promised if it achieved certain goals, and notably fuel efficiency standard goals. And although Chrysler had been negotiating with Fiat even before the government had been involved for joint ventures and so on, Fiat was attractive to the Obama administration because of its small car experience. And in fact, the distribution of the interest in equity to fiat was explicitly justified because fiat could contribute smaller car technology. And so you might say that this was required because of the way that the market was shifting at the time, but I think that the description of the justification showed that it was also motivated, if not predominantly motivated, by the push towards smaller cars for environmental goals. Otherwise, the sale also gave a 55% interest in the equity to a trust for the health benefits of the employees and retirees, and as well as a substantial debt claim to them. And it'd be one thing if the contribution of the federal government was used to finance this, but there is substantial basis to believe that some of this was co-funded by bondholders, by the pre-bankruptcy bondholders of Chrysler. And they objected to it on that ground that it violated their priority rights because they were paid cents on the dollar while a substantial payout was made to the unsecured claims of this benefit trust. They were concerned that they were disenfranchised by the process and that their value was expropriated through the take it or leave it structure of the sale. So we don't want to adjudicate whether that was the case and the extent to which it was the case. It certainly is possible, and it was certainly within the reach of government activism in order to affect that redistribution. And that raises certainly the concern that perhaps more oversight should be exercised by the court in policing or in monitoring this sort of behavior in cases going into the future. Many scholars were critical, but they also acknowledged that the Chrysler and GM bankruptcies were perhaps outliers. And we don't want so much to focus on that question as to say that we can anticipate on the horizon there'll be more strategic behavior like that will raise similar concerns. So with that, let me turn it over to Jared to present the second half of the paper.
Right, thank you, George. So the second case study that we use is different. It's the 2019 PG&E bankruptcy. And a word, I guess a disclaimer before I get into the meat of the presentation. I was involved in the bankruptcy as an advisor to the California State Senate, but everything I'm going to discuss today is my own opinion, and it's drawn from public sources, and it's not particularly a controversial recounting of the facts. Right, and the reason we find this case to be so interesting is because it involves the government taking control of the bankruptcy process and using it to implement certain policy goals. But it's not the federal government, it's a state government, and they didn't use DIP financing to do it. Rather, they dangled an insurance fund and passed a state law that copied in many ways the coercive provisions you find in a DIP credit agreement. It just used state law to do it and hung everything around access to an insurance fund. So before I talk about exactly how that worked, PG&E is a really big company, and it's a lot more important than you might even think if just acknowledging the fact that it provides power to 16 million people in one of the wealthiest and most economically important regions in the world. I think of PG&E as accomplishing three policy goals for the state of California. The first is that PG&E provides power to a large part of the state, including people living in remote areas where the provision of electricity to people living in the urban rural periphery may not be an economic thing, but it's something that PG&E does, and it does so by cross-subsidizing the cost of delivering that electricity to people who, to people in the Bay Area. The second thing that PG&E has helped the state to do is to steer the transition for the state of California to clean energy and to help the state of California become a leader in clean energy. And the way this has worked is through a series of power purchasing mandates, where PG&E was told that you need to get a progressively larger proportion of the power you generate from clean energy sources. The state handed PG&E these mandates at a time when there wasn't sufficient supply in the marketplace to actually meet those quotas. And then PG&E went around ordering, or I guess using a series of long-term contracts called power purchase agreements, where they contracted with people saying, we want to buy, X whatever of solar from you. And then the contract counterparties then use the PG&E purchase order to finance the construction of plants in order to then produce the power that PG&E needed. So in this way, PG&E has been the straw that stirred the drink in the clean energy transition in California, and a crucial part of California's strategy to become a global leader, not just a national leader, but a global leader that's important to us in California in climate policy and in the transition to clean energy. The third thing that PG&E does is it helps to subsidize California's homeowners insurance from fire risk. Let me get more into that in a second. Right, so the background to the bankruptcy filing, there's a story that many people know, which is PG&E equipment caused billions of dollars worth of damages in a series of fires in 2017 and 2018. What's less popular known is that PG&E is subject to a strict liability regime for property damage that's caused by its equipment, which is a doctrine which is known as inverse condemnation. And the problem that PG&E found itself confronting in the later part of the 2010s is that climate change had made its basic activities much more risky than they had been before. PG&E had always been running power over hundreds of miles of remote territory, but that territory was increasingly dry, and PG&E's equipment and power grid was increasingly in a state of disrepair. PG&E has power equipment in the field that is so old, they've lost track of when they ordered it and how old it is. So it's a company that has governance issues as well. And those risks associated with those activities were grossly worsened by climate change. And PG&E found itself suddenly living in a world where a gust of wind could knock over a tree and cause $10 billion in damages. That's a really challenging world for any company to operate in. And this is probably the most challenged firm that I'm aware of in many ways in the American economy, right? And so that's the liability regime. And then there were a series of fires in 2017 and 2018 that left the company with tens of billions of dollars in tort liability and no ability to offload future risks onto the private insurance market. And then to make things worse, the California Public Utilities Commission appeared to adopt a policy of not allowing PG&E or other public utilities to pass the cost of wildfires onto ratepayers. This created a massive solvency crisis for PG&E that pushed them into bankruptcy, but it didn't have to. The state of California has an annual budget of $280 billion or so, and they could have chosen to appropriate money to solve PG&E's problems, but they didn't, for several reasons, three of them being especially noteworthy. The first is that the state wasn't interested in becoming a funding vehicle for cutting down trees in Northern California. The state wants to fund things like poverty and education, the transition to clean energy, healthcare to the uninsured. Nobody thought that Sacramento should just essentially become a funding vehicle for reducing the risks of wildfires, as horrific and destructive as those fires were. The second reason is that wildfires in California become highly politically salient every fire season, which tends to start in June or July, and then it tends to fade once fire season ends, except of course, if you live in a community that was obliterated by that season's wildfires. And then the third reason why the state didn't want to do anything is because nobody wanted to be associated with a PG&E bailout, and any action taken by the state to help PG&E risked a public relations backlash, given that it was the least popular company in all of California. So taking the 2018 and 2017 fires together, the company faced the need to pay as much as $50 billion in damages, probably closer to $30 billion, but there were $50 billion in asserted claims. And when the state legislature indicated that it wasn't going to bail the company out, PG&E filed for Chapter 11 bankruptcy. They filed for Chapter 11 to do two things. The first was to settle the fire claims, to take advantage of Chapter 11's appointment of an official committee of fire survivors to negotiate with. And the second was to negotiate a viability framework with the state because as things stood, they had a strict liability regime and no ability to acquire private insurance to deal with the risk. So once PG&E landed in bankruptcy, it became very clear that PG&E's use of Chapter 11 powers was going to be strictly bounded by political realities in California, because there was no way to do a Chapter 11 plan without state support. Right? The first thing that PG&E was going to have to do was make sure that they paid all of the fire survivors in full. To the extent the state was going to help PG&E, that help had to come with a price, and the price was avoiding the public spectacle of the victims of the horrific fires not being paid in full on their claims, which would have been especially worsened because there were, Wall Street bondholders with claims of equal priority who also would have gotten something out of the bankruptcy. So the narrative was deeply politically destructive. Another thing that PG&E was going to have to do in order to adapt to what the state's demands were going to be was to somehow reduce the risk of future fires, to take steps to reduce the risk of their operations within reason. If they were to spend $150 billion, they could probably drop the risk of future fires to close to zero, because they could take actions to harden their grid in order to avoid any fires happening in the future. They could make their grid, highly windproof, but nobody wanted to spend that amount of money. The third thing that the state was going to need PG&E to do was to continue to provide power to everybody in Northern California, and not to, for example, do a bankruptcy plan where they would exit the provision of power to people in remote areas, kind of like divide the company into good PG&E and bad PG&E, where good PG&E would help pay for Google server farms in the Bay Area, bad PG&E would, be a constant bankruptcy repeat refiler that provides power to people living in remote regions. The fourth thing that PG&E was going to need to do in order to satisfy the state was to protect the state's climate goals and clean energy infrastructure. The green energy industry in California became terrified after PG&E filed for bankruptcy that PG&E would not make good on these long-term power purchase agreements. And the result of PG&E not paying those agreements in full would have destroyed the credibility of the state of California as a contract counterparty for the growth of the clean energy industry, which would have been devastating perhaps for California's status as a leader in clean energy, which is something that the California political establishment in the Democratic Party cares deeply about. PG&E also wasn't going to be able to fund a bankruptcy plan with a rate increase that was proximately caused by the bankruptcy, because that would incite public outrage. And then the state also cared deeply about making sure that the PG&E bondholders were treated fairly in the Chapter 11, that there wasn't a kind of bankruptcy plan that redistributed value from the bondholders to the fire survivors. And that's because California and California state agencies and big California corporations are constant repeat consumers at the capital markets. They're constantly borrowing lots and lots of money to do things. And there was worry that there would be reprisal from Wall Street in the event that there was something weird that happened in the Chapter 11. So Governor Newsom used a two-pronged strategy to take control of the PG&E Chapter 11 and to make sure that the state's interests were protected, and the PG&E acted in a way that was consistent with what the state government cared about. The first thing he did was to, mastermind. It was really the state legislature that did it, but he signed into law a law that offered PG&E a viability framework through a wildfire insurance fund that would be paid through a combination of contributions by the state's three big utilities, as well as ratepayer contributions, although that was somewhat glossed over. And PG&E was offered access to this fund. It's kind of like reverse dip financing in some ways. They said, okay, you need money to reorganize. Here's this big pot of money, but to get it, we're going to put a bunch of things into the state law saying you need to get out of bankruptcy really quickly. You need to submit to a new and more hands-on regulatory regime that'll provide a pathway for the state to seize control of PG&E assets without an additional bankruptcy proceeding in the event that there are a lot of future fires. Whether that's enforceable in a subsequent bankruptcy is a separate question, but this was something that the state of California put into effect. PG&E also had to pay all of the fire survivors in full. They had to protect the state's climate goals, and they couldn't take actions in Chapter 11 that would imperil the things that the state wants to do in the climate area. And PG&E also pledged not to fire any workers, and through the bankruptcy process even gave large raises to its unionized employees through bankruptcy negotiations. The second thing Governor Newsom did, and this is where it really felt very activist investor-y, is he hired a top bankruptcy law firm, O'Melveny and Myers, and he weighed in on major motions just like an official committee of unsecured creditors or an ad hoc group or a hedge fund would. Right? PG&E filed a motion to extend exclusivity. Governor Newsom filed something saying not so fast. PG&E filed a disclosure statement. Governor Newsom filed something saying, I don't know that there's adequate disclosure in here, just like you would expect an activist investor would. And in that way, it's a different type of activist investing than we saw in the Chrysler bankruptcy, where Governor Newsom, used litigation and used the bankruptcy bargaining process to drive the things that he wanted. He filed objections and then he bargained in the shadow of those objections, mindful of the fact that he had a lot of bargaining power given, his stature as governor of the state. At one point, he forced a mediation where all of the hedge fund creditors flew from New York to Sacramento to meet with him in his office. He was extremely hands-on in steering the outcome of the case. Once the fire survivors settled with the company, he used a public letter to force additional concessions from PG&E, including that process which I've already mentioned, where PG&E agreed that the state could seize its business in the event it became a serial fire starter and that it wasn't making adequate investments in safety, right? So through this, Governor Newsom was able to greatly influence the outcome of the bankruptcy process and to get an outcome that he could live with, an outcome where the fire survivors were hopefully paid in full, although that may not have actually worked out like that, and the state's climate interests were protected, right? So a couple of downsides that I want to notice of this, or I want to note here at the end of the discussion of this style of bankruptcy activism, this use of the bankruptcy process by governments to achieve policy goals, right? The first problem that we're especially concerned about is the idea that when policy is made through Chapter 11 and in the bankruptcy bargaining room, there's less transparency and democratic accountability that exists when everything is run through a state legislative process. Right? State legislative processes have well-established policy infrastructures that are populated by stakeholders. They have veto points, and there's a level of democratic accountability that's very important. As bankruptcy scholars, we're used to thinking of bankruptcy as a place where there is a lot of transparency relative to normal corporate law. But bankruptcy law, even though it's a fishbowl for corporations, offers less transparency than what goes on in the State House in Sacramento or in Washington, D.C. Right? The second risk we want to highlight is that it's possible that as bankruptcy activism becomes more common by government entities, you may get, not necessarily, the resolution of important issues, but partisan policymaking, which can have upsides and downsides. The third thing I want to note is we risk the subordination of bankruptcy policies to other policies. For example, PG&E in Chapter 11 left bankruptcy with more debt than it came in with. They essentially converted tort debt into contract debt. And that fit the state's interest in making sure that the fire survivors were paid in full. But that's inconsistent with the bankruptcy policy that we're all familiar with, which is a firm shouldn't reorganize in a Chapter 11 plan that's likely to be followed by a future restructuring. PG&E came out with a big insurance fund, but in some ways more financially brittle than it was going in. Another thing is that bankruptcy courts are fundamentally, as courts of general jurisdictions, not experts in a lot of the matters that are in front of them. Judge Montali in PG&E wasn't an expert in energy or safety in California. The bankruptcy judge in Chrysler wasn't an expert on what consumers would want to buy, and was it a good idea to condition or to give Fiat a better position in Chrysler in the event that Chrysler made additional small cars. There's expertise in the system, but sometimes you go into bankruptcy in order to avoid that expertise. And then finally, to return to something that George said, it raises a lot of questions about what public policies will matter in bankruptcy, how they'll shape bankruptcy outcomes and bankruptcy distributions, and how bankruptcy law ought to think about that. And with that, I think we're excited for your questions.
All right, we should have time for a couple questions. I'll hand it off to panelists to go first. We have a question from Professor Pardo. So Professor Pardo, go ahead.
Great. George and Jared, thanks so much for this really fascinating and provocative paper. I like the themes a lot. They relate to some of the work that I've done with Catherine Watts on bankruptcy policymaking, and we've talked a lot about how residual bankruptcy policymaking, one of the downsides of a judicially administered statute is having lack of democratic accountability. So I like the points that you guys are making with this paper. And I guess the question I had, I'm wondering whether you guys see a distinction, a valid distinction between the sort of policymaking going on in Chrysler and GM versus in PG&E, given the fact that in the former, it was the federal government. So one could take a view that bankruptcy is a benefit program created by the federal government. And depending on how robust a view you take, you could either view that benefit program as being completely public, or you could take a view along the lines of a Melissa Jacoby, a public-private hybrid partnership or what have you. But if you view it as a federal government benefit program, obviously subject to the strictures of what Congress has said you can and can't do according to the bankruptcy code, one might nonetheless take the view that, well, it's the federal government's program and they're free to administer it within the strictures of the bankruptcy code, but to otherwise further whatever goals they want. And if they want to step in with something like a GM and Chrysler and dictate other federal policy that can coexist with bankruptcy, then that's a good thing. Versus if the state government is coming in more as a participant and litigant in a way that is distinct from the federal government, is that maybe then a less desirable role for government activism in bankruptcy?
We have a coordination problem, but I'll go ahead, Jared, and please correct me and fill in the gaps. Raphael, that's a great question. For us, the important parallel is to activism, and I think some of the arguments that you made might have applied to any activist, which is that, the bankruptcy code says you've got certain rights and you can provide DIP financing and you can, but the court has oversight over it, right? The court puts limits as to what an activist can do, and in fact designates votes and says you might have a claim, but you can't vote because your motivation is extrinsic to bankruptcy policy and is inconsistent with bankruptcy policy. And that's really up to the court. And you could imagine the court saying a similar thing to the executive. I'm not talking about Congress. I'm saying to the executive to say that, okay, you're providing the rescue financing, but that doesn't mean you get to dictate the structure of the sale. You get to say, for instance, that you use the leverage that you get by providing the financing to say that the sale has to be subject to, certain debts have to be assumed by the acquirer. That's, you don't get to call the shots the same way as if you were an activist investor. And that's really up to the judicial discretion, I think, to be able to police it the way it does with an investor, and how it should go about doing that, and what is an ulterior motive, and is climate change an ulterior motive in bankruptcy? It's one thing for the court to bear that in mind. It's another thing to have an activist government compel a climate change policy using its leverage as a DIP financer, for instance. Jared?
So I think thank you, George. And so I think that's a wonderful question, and it flips the way that I would think about the legitimacy, or not the delegitimacy, of these two interventions on its head, because my thinking is that Chrysler is a bona fide private firm. I guess to the extent that we really have private firms, which is now something of a new debate in my mind, PG&E is very much a creature of California state policy and state law. PG&E is a privately owned public utility that's subject to an incredibly strict regulatory framework that goes way further than anything Chrysler is subject to. So, I might say that the state of California's intervention there is more legitimate because to some extent, it's really just the state's vehicle, which uses private capital to do public things under a strict regime of public oversight. So to the extent that there's continued state intervention into its operations, that's a continuation of where things have always been. Yeah, so I guess I would echo what George said, which is that there is a real question in these interventions about to what extent bankruptcy law is prepared to police excesses and what excesses actually are, and where bankruptcy policies ought to once again beat out non-bankruptcy policies. And there, I think, is really the question of the legitimacy of the intervention, at least insofar as, if you start from the perspective that bankruptcy policies ought to predominate in bankruptcy courts. But yeah, that's a really neat formulation that I'll have to think more about.
And just one last comment on that point. But so, to use George's example, so for example, the designation of votes, obviously it's a statutory provision, but there are a lot of gaps left in the statutory provision for the courts to use their discretion. And alternatively, one could imagine we're in a world where it's an agency administered statute, and an agency would go about the question of what sort of factors should be taken into account when we designate a vote. But I think we would recognize it doesn't matter who is the administrator, there's still a bunch of discretion there, and what's happening is there's policy making. And so I guess the point I was trying to drive home was whether, given that amount of discretion to engage in policymaking, and that's really what's happening at the end of the day, whether whoever the administrator is, should they be more receptive to competing non-bankruptcy goals when what's trying to be promulgated is a federal policy as opposed to a state policy. But Jared, I think you gave a very nice response to kind of how we have to think about it in the context of the PG&E case.
Professor Westbrook is up next in the queue.
Thank you. Yet another really interesting paper. I learned an awful lot from this paper and from your presentation. So thank both of you for that. I have three comments to which you all may or may not have any reactions in the short time we have. Number one, I find myself in the context of the PG&E case particularly, but maybe in Chrysler as well, harking back to Odette's point about how bankruptcy sometimes may serve as a forum or an atmosphere or a container in which agreements can be achieved that are very difficult to achieve, especially where they have substantial political aspects. And I think that's a very interesting idea. Whether that's a good thing or a bad thing is an interesting question, but she brings it up in the context of sovereign debt, and somewhat similar consideration, it seems to me, apply in Chrysler and perhaps even in PG&E as well. Secondly, it strikes me that the number one justification in Chrysler is, well, the government had the money, right? And the guy who comes in with the money, the post-petition financer, we have been taught, and I'll be talking a little bit about, has a lot of discretion over the conditions to place on the financing. On the other hand, we know from Jarvik, don't we, that there are limits to that the bankruptcy law is not going to permit unlimited discretion just because you have the post-petition financing available, and these are the terms that you want in the plan. So those sorts of analogies strike me as kind of interesting also. And then the final point, again, somewhat harking back to Odette's paper, is the question of transparency. How much can these problems be solved by transparency? There was, I think, a serious lack of transparency in the Chrysler case, however you come out on various merits points. And it seems to me that maybe there ought to be special rules that when the government gets into a bankruptcy case, there ought to be a full undressing with regard to its requirements and positions. So anyway, really interesting paper, opened up a lot of new thoughts for me.
Thanks, Jay. That's actually, those 3 points are extremely helpful. A thought experiment might be, suppose if we go back to Chrysler, if one of the conditions they placed on the sale was that new Chrysler would adhere to all the existing fuel efficiency requirements, we would say, absolutely,
Sure.
No problem with that, they exist. if they use the sale process to increase the fuel efficiency standards that Chrysler would have to meet for whatever reason, they decided to do it to promote climate change policy, I think that we might be more inclined to say that's not what bankruptcy is about. You might vindicate existing policy in bankruptcy, but you don't make new policy in bankruptcy. And that's sort of the distinction really that we wanted to draw. If they're actually, and it's an extreme case when I'm talking about the fuel efficiency standards, but I think that there are similar distinctions to be made between whether they're pushing new policy, in which case, do we force them to go back to the democratic process, to the notice and comment, and say you can't end run that, no, even if there's transparency, or do we say, well, bankruptcy is a forum for sort of engaging all these trade-offs, including these non-financial policy trade-offs.
Interesting.
Yeah, and I just want to follow up very quickly with, your first point. This bankruptcy is a place where you can do deals and where things can get done, and it's a forum for resolving disputes. It seems like we're, hovering around a collective sense, in several of the projects that we've seen so far, of society has a number of really hard choices to make. And maybe bankruptcy is a good place to do it. And if that's where we come out, then this governmental activism in bankruptcy is probably, as George and I think we're identifying, something that will increase in, how often it occurs over the next few years. But maybe it's something that we're comfortable with and that we would want to shy away from imposing additional democratic or procedural guardrails on, because by doing so, we just increase, the level of stagnation around resolving disputes and the level of polarization in our society and something like that. So these things really cut both ways, and it's not an easy set of questions that these examples raise.
And then I think we have time for one final question from Professor Lienau.
Sure, I'll try to be fast, but I echo, this is fantastic. I really enjoyed it and learned a ton. And I guess the question does follow up on Jay's first point, which is I wonder if you can even answer all the questions you're trying to answer without going deep into sort of meta bankruptcy policy theory, right? I mean, I feel like I know you don't want to go there and you say, well, we assume that bankruptcy policy is supposed to hold in bankruptcy court and bankruptcy cases, but I think it's like, well, what does bankruptcy policy mean in this world, right? Where the activist investors can have as many major policy ramifications in their actions as a government investor. And if that's the case, really what actually is the boundary there, right? One of the things I tell my students sometimes is, look, bankruptcy is a suggestion that financial contracts and economic contracts are embedded in a social contract. That is the meta idea of bankruptcy. So if that's the case, maybe you need to be asking actually what is the nature of the social contract and what are the ways in which financial contracts are embedded within them. And if you think that actually maybe that is the case, and you also have commitments to ideas of democratic legitimacy, transparency, then you incorporate those ideas into the existing bankruptcy process rather than saying we're going to take those out and put them in some other location. So that's way, bigger than probably what you want to get into, but it was making me think big. So I feel like that's a good thing.
That's a key question. And it's not that we don't want to engage with that, because I think you have to engage with that, but just not in our first foray. But I think that those questions have to be answered. And we do think that it's important to distinguish between the question of what bankruptcy policy is, whether it incorporates the greater social good, and the second one is the role of the executive branch in doing that, in exercising the leverage that it has through these rescue financing or post-petition financing. Should we let them do that, or should it be more of a pure process without that sort of activist influence?
Yeah, and this really does echo back, as George said, and as we say in our paper, to that debate between, now Senator Warren and Douglas Barrett over what exactly should bankruptcy law care about. Tony, Josh, and I just recently had a debate, somewhat on Twitter, although they wrote an article, so they clearly have the better of the argument, over whether or not Hertz over the summer should have been allowed to sell, likely worthless stock to retail investors. And my point was no, because bankruptcy law cares a lot about the legitimacy of the bankruptcy forum, and that's a policy that bankruptcy law, it goes to lengths to vindicate. Their response is, well, that's not a bankruptcy concern, and the bankruptcy court should only deal with bankruptcy concerns. And so, everything we're talking about today, including questions that are raised by your presentation as well as by Laura's, come back to this, what is bankruptcy? Is it just is it a forum for alternative dispute resolution that has an ugly name on the door, where everything at the end will yield to all of the various powers and the bargaining leverage of the parties and the rules and the things that they have to deal with in order to get the firm through Chapter 11? Or is it a body of law that has its own substantive concerns that ought to be vindicated? And how do those concerns interact with other concerns? I don't think I have a resolution of that question, but after this conversation, it's clearly one that looms larger in my mind. And maybe, George and I will have to sit down and work on this big bankruptcy meta question next. But thank you so much for the question.
Thank you so much, Professor Triantis and Professor Elias, for your presentation. I will now be handing it off to our final presentation by Professor Westbrook.
Professor Westbrook, I believe you're still muted.
I'll probably be my thank you to the law review and to Vera and Matthew would go better if I was actually on the microphone. So thanks to both of you very much, and to Professor Pardo and Emery as well. I'm happy to present a paper with such a distinguished panel, although that's also intimidating to a large extent, having heard so many really terrific papers already. I'm also very conscious of that I'm in this dangerous space between our much appreciated audience and the rest of their day. So I'll try to make this straightforward and short. I also want to avoid having too many numbers in an empirical paper, right? So often empirical papers end up, as you're listening to them, it's like the sportscaster on the evening news. He says, great news from the world of sports today, 7-5, 3-0, 2-0, 1 to, no, we don't want to do that. And so I'm going to talk mainly in general terms. The tables that are attached to my paper are more specific. Okay, this paper is a simple empirical report. We're doing more work on the data. We hope to do more sophisticated work on the data, but we wanted to get out these data in order to invite comments and suggestions that will help us in doing exactly that. In general, in recent years, there's been widespread acceptance of the idea that creditors, really lenders, often secured lenders, are in control of Chapter 11 cases. That is to say, are in control of how those cases are run and how they are resolved. That idea has been generally accepted without a whole lot of actual data to support those conclusions. Recent articles by Fred Tung and by Kenny Oak and Elias have contributed, really for the first time, some terrific data to that conversation, talking both about the existence of a widespread lender control of Chapter 11 and also about the effects of that control. So really, this paper simply builds on those. And to summarize, see if I can find that slide. Oh, I thought it was up. Oh, I definitely clicked on the wrong thing, didn't I? Oh, sorry for that. Bear with me just a second. Oh, here we are. To summarize, this is my only slide, but to summarize, our paper is pretty simple. Our data permit a strong inference that control of Chapter 11 by lenders is widespread in both public and non-public companies in Chapter 11, although it is by no means universal in Chapter 11, and that lender control reduces the value of those companies to unsecured creditors and other stakeholders. That's our conclusion in a nutshell. And if can you all share that or not? Okay, if
Sure.
not, I just read it to you, so it doesn't really matter.
Apologies.
No. Golly, I keep clicking the wrong things today. Bear with me. My students are very patient, and I guess I have to ask you to be as well.
We can be patient too.
Okay, very good. All right, so number one, this is a report from the Business Bankruptcy Project. We've been doing this since 1995, believe it or not, and this is the latest iteration. Our current study is of samples of Chapter 11 cases from Delaware and the Southern District of New York from 2014 and 2018. We took, in each case, in each year, we took 50 cases from each of these two very important jurisdictions. But in the process, I should make it clear, our unit of observation is either a single standalone case, a company that doesn't have any affiliates, that are at least no affiliates that are filing also, or a corporate group. So because we deal with a corporate group as one entity for observation, our 50 cases in each jurisdiction each year actually includes most of the cases in those jurisdictions, especially in Delaware, because you will not be surprised to hear that Delaware is dominated by corporate group filings. I think there's only about 50 or 60 cases in Delaware, for example, in 2018 that are not part of our sample. Okay. And the appendix to the paper goes into much more detail as to our methods. Tung and Odette and Ellias show two things about lender control of DIP lending in public companies. Number one, it is widespread. And number two, in at least some respects, it reduces the value of those companies in Chapter 11. And these are obviously very important conclusions. Both articles are terrific and do very sound and careful analysis. But both of them are inherently limited, as all empirical studies are, by some basic choices in their construction. Both studies are only of public companies that come from the wonderful Lynn-Lepucki database. And therefore, they are limited to public companies and not companies that are non-public. And there are lots of companies filing Chapter 11 in our districts and around the country, of course, that are large and important companies, and many, many smaller companies as well that are not public companies. So basically, what we have set out to do in this paper is to talk about whether or not the findings of those two papers, the two public company papers, are likely to be reflected in the private, on the non-public side as well. So it's a modest goal. I hope we're successful with it. What we have found is two basic ideas: that control by lenders is widespread in non-public as well as public companies, and that control reduces value. So, I'm going to very briefly talk about what those two articles say. One of the authors is with us today, so I really run a risk of being strongly corrected in my attempt to all too briefly summarize the results. But essentially, Fred Tung set out to show that he could not find a good explanation for why there was an increase in Chapter 11 of what he calls sweeteners. Those are provisions that are not found in conventional commercial lending that are very valuable to lenders and arguably may reduce the value of the companies that are forced to grant these sweeteners. And what he did was say, look, the explanation or the justification for these sweeteners is that when you, because it's a Chapter 11 loan, it really turns on credit availability, whether or not credit is available to these companies. And that, of course, affects in a competitive way what the terms of bankruptcy DIP loans are likely to be. Crucial to both of these papers is the idea that DIP loans are very profitable. And there's a lot of literature that suggests that's true. And so the question is, in that case, you would expect to find that the interest rates and other terms in these loans are consistent with what's being offered in the marketplace for loans of equal profitability. Both papers rely on the proposition that that's not true. And if that's not true, why is it not true? So in Fred's case, he found that for ordinary conventional covenants, the sort of covenants in a loan agreement that you would expect to find in or out of Chapter 11, that indeed those covenants go up and down in terms of their severity and their constraint on the borrower as a function of credit availability at any given time in the marketplace. But these sweeteners, as he calls them, do not. That these things seem to be unrelated, or indeed maybe even inversely related to the profitability, or rather to credit availability in the marketplace. And he, at any given time. And he then concludes from that what we're looking at here are unfavorable, unduly unfavorable terms for Chapter 11 debtors who are perhaps under the control of the lenders making these post-petition loans. Secondly, Jared and Ken have this terrific paper that they in which they argue that so much is it true that these DIP loans, post-petition loans, are unfavorable to debtors, that they call them bankruptcy process sales and bankruptcy outcomes sales, that these lenders so control the process that they are able to get very favorable terms for them, very unfavorable terms for the debtors as compared to the marketplace. And the result of this is that they control the bankruptcy process. They also show that there are lower returns for unsecured creditors in these cases where they find that influence. So taking those two things as a given, at least in terms of our current knowledge, our current understanding of what's going on in public company cases, and I should say both of them take data over a long period of time from those cases. The question is, can you make the same kind of finding on the non-public side by looking at the filings in Chapter 11 cases, and in our case, in two districts, Delaware and New York, that take a lot of the most important bankruptcy cases filed each year. And as our venue discussion emphasized, these are not necessarily cases confined by any means to companies that are based in Delaware or New York. The fact is that the same kind of information is not available for private companies or non-public companies as for public companies. Public companies under Securities and Exchange Commission regulations have to provide far more information on an ongoing basis and then at the time of bankruptcy than do companies have to provide in the bankruptcy process when they file for Chapter 11. And even to the extent that some information is required, that requirement is not really enforced. There's really no mechanism by which anybody, the clerk's office or anybody else, makes sure that that information is made available. Of course, there can be transparency required by the court as the case goes on if someone makes an appropriate motion, but that information is not readily available from docket sheets. So what we could do was not to backstop and go behind and see whether or not exactly the same sorts of results are to be found in Chapter 11 cases that are not public. What we could do was to take a look and see whether or not the indicia of control and of loss of value that they found in those two articles are also extant in these non-public companies. Because that's information we could extract at a reasonable cost and time from the information available in the Chapter 11 dockets. So there are three of these that they talk about in these articles. The first one is the existence of a DIP agreement or order. And there we found in 2018, and I'm just going to limit myself to 2018 for ease of discussion. In the 2018 cases, a approximately half of them have a DIP order, and that's up from 44% in the 2014 cases in these two districts. These are very close to the percentages found by their two studies of public companies. So a very similar kind of distribution of debtor in possession agreements and orders. On the other hand, our look at the two countries, Delaware and New York, finds that these orders, DIP orders, are far more common in Delaware than they are in New York. 75% of the cases in Delaware, only 25% of the cases in New York. Both figures, by the way, are increases, significant increases since 2014. The next indicia that they take, control and of possible injury, are milestones. That is to say, provisions in DIP agreements that say a certain result has to be accomplished by a certain date, or it is an event of default and an opportunity for the lenders to take over the case, and various other things that follow from those agreements. What we found was that 40% of our cases reveal, in 2018, revealed DIP milestones. They're down a little bit actually from 2014, but there are a lot of those cases then, almost half of the cases, that have the milestones that they identify as both indicators of control and as cases that are likely to impose loss of value in the form of DIP financing terms in where they are found. And the second one is roll-ups. We've heard some discussion of roll-ups. And apparently there's some controversy about whether roll-ups are good or bad. I think there's an awful lot of opinion that says roll-ups are not good, that they tend to provide an unjustified and costly priority that is not awarded by the statute or by contract to lenders. A roll-up, for those who haven't run into that phenomenon, is essentially the returning of pre-petition debt into post-petition debt. So it is promoted to a vastly higher priority. And that can be done in various mechanisms, but that's the overall effect. The overall rate in our two districts was 30%, but there is a much higher rate in Delaware. And so this is a second indication of indicia that they found studying the much more extensive data available in public company cases, as that they found likely to cause a loss of value in these cases. And finally, I'll just note the additional data that we have of things that were not covered in these two articles, were discussed, but not statistically analyzed. And that's restructuring support agreements, often called RSAs, and carve-outs. An RSA serves many of the same functions as a DIP agreement. It serves the function of ensuring that that financing will be made available to the debtor, but on the following terms, often very restrictive terms, often terms that very much constrain what the debtor can do in the Chapter 11, and that may amount, as Jared and Ken say, to a bankruptcy process and bankruptcy outcome sale. We found those in 40% of the Delaware cases in 2018. Far lower percentage, once again, in the Southern District of New York. The overall rate between them was 30%. Oh, wait a minute, I'm sorry, I just read the wrong numbers. However, RSAs were found in about the same ratio as for DIP agreements, and in roughly the same relationship between sample years in Delaware and New York. And finally, let me say something about carve-outs. As many of you know, a carve-out is an agreement by which a controlling lender under a DIP agreement says, well, you can use some of my money for certain purposes during the case, but no more, and not for other purposes. And very often this is to pay the debtor's professionals, especially debtor's counsel, and perhaps in a number of cases, to pay the counsel of the Unsecured Creditors Committee, which is most often likely to be the most important adversary of lenders in Chapter 11 cases. So the carve-out amount is very important as to whether or not these lenders are going to be paid if the DIP agreement, in effect, puts all of the other funds and resources of the debtor under the control of the lending group. We found that in our samples that at the carve-out in 2018, more than a third of the cases revealed a carve-out. And once again, the great majority, as the table shows, the great majority are in Delaware. One is tempted to say that you file in Delaware because the lenders are in control of the case. That's clearly an overstatement, but one is tempted in that direction because the difference is so sharp. It's worth commenting, by the way, because that the two districts that we studied, Delaware and Southern New York, contain the overwhelming majority of public companies that were studied in the other two articles. So there's a lot of overlap between our districts and the ones that are, in effect, the ones that were studied in those two public company articles. Finally, I don't want to use up all of our time here, but finally, neither article addresses in any great detail, where does this control come from? How is it that lenders are able to dictate the terms of the DIP agreements in ways that actually do violence to or do harm to the value of these companies? And there are a whole variety of possible explanations that could be put forward. Ken and Elias and Jared offer, for example, the explanation that management may be bribed. In fact, they don't use the word bribe. That's Alan Schwartz's famous or infamous word from one of his articles. But in effect, that management might be induced to give away the store in terms of protection and benefits for themselves. We haven't looked at that. I don't have an opinion about that. It's plausible, but I don't have an opinion about it. On the other hand, the other most obvious explanation for these uncompetitive terms is that the lenders go into bankruptcy with an overwhelming dominant security interest. They have a security interest that so controls the assets of the company, no doubt hedged about with lots and lots of covenants that are easy to violate, and therefore give the lenders prior to bankruptcy the power to close the business more or less whenever they want to. That's exactly where the leverage comes from in many of these cases. So we took a look at the presence of dominant security interest. We define a dominant security interest as one in which the secured debt exceeds 75% of the assets. We did not attempt to go asset by asset in that analysis. That would be quite an enormous task, especially in the case of the larger companies. But we do have the overall figure of a secured debt that is 75% or greater than the value stated in the bankruptcy schedules for all of the assets of the company. And it turns out that more than half of the cases in 2018 in those two districts had dominant security interest. Now that statistic is important for two different reasons. One is it means a large number of companies go into bankruptcy essentially helpless to lender control. That whatever the lenders want to do with the case, that's what will be done. And the articles that I've been talking about, the public company articles, strongly suggest that the result is a loss in value overall in the Chapter 11 case, perhaps a serious loss in value. Indeed, in 40% of our cases across the two districts, again, especially in Delaware, we find that 40% of the companies have secured debt that is more than 100% of the total value of their assets. Hard to believe that such companies have any real discretion vis-a-vis whatever the lenders want to do with those companies in Chapter 11. And both of those have increased since the filings in 2014. But there's another equally significant point to be drawn from that, and that is that a large percentage of the cases do not fall into this control by lenders category. What we have not yet been able to do, to the extent that we hope to, is to understand what is the difference between these two different groups of companies. What makes the difference between a company that is where management has essentially given away the store and those where management may retain some significant capacity to direct the future of the company in Chapter 11. We don't know the answers to those questions, but I think they're really important questions. The larger question, in a way, though, may be, when does this take place? If what we witness in these dominant security interests is a control transaction, an idea well familiar to us from corporate law, and we know that control transactions are very important and they should be regulated in various ways, because selling control of a company is a very important thing to do. Transparency is important, and from transparency, presumably an examination of whether or not control is being sold at a reasonable price and for good and adequate corporate reasons. This control transaction in Chapter 11 takes place before the bankruptcy, according to our data, in at least half of the cases. And if that's true, or at least there's a strong inference that it does. And if that's true, then we have to say, is that good policy? Is that a good idea? Indeed, do we actually have to look seriously at secured credit law, whether it's directly under Article 9 or indirectly under the bankruptcy code in terms of look back, claw back kinds of provisions, disclosure provisions as to why control was granted during a certain period before bankruptcy in the form of a dominant security interest? I think these are questions that we ought to be looked at, that we ought to be looking at in a serious way. And I think they're strongly implied by our capacity to extend the findings of Fred and Ken and Jared to the whole range of companies in Chapter 11. Okay, well, that's what I wanted to share with you, and I would look forward very much to comments and questions.
Thank you very much, Professor Westbrook. As with the past question and answer sessions, we'll begin with panelists and then move to attendees. So any panelists that have questions can either raise their hands or unmute. Professor Ellias.
So I won't take too much time because I plan to email you later with comments in greater detail, and I see there's a lot of excitement in the audience to comment. But I love this project, as you could imagine. And my comment would be that since you have these more recent credit agreements than the two studies you cited rely on, my paper with Ken ends in 2012. I think Fred's paper also ends sometime around the same time. By the way, this isn't public, but when I replicated Fred's tables using our data, I found approximately I could replicate his figures almost. So I feel very confident that both of the studies are saying similar things and looking at similar data. But I'd love to know, because you have 2014 and 2018, to what extent there are changes between those 2 years, and given the quality of what you have, and then you have these 50 cases from each period, I'd love to know, like, are milestone periods becoming shorter? One of the things that I've noticed in the data when I've looked at it is that bankruptcy cases are shorter on average in 2020 than they were in 2014. So I'd love to know to what extent that's reflected in DIP loan contracting. But anyway, I'll send you an email later. This is wonderful. Thank you so much.
Well, I really hope you do. I would love your suggestions. Part of the problem we have is that we just have so much data. We're kind of drowning in it, and I'd love to have thoughts about where we might focus. But there's no question that the indicia of control have increased substantially from 2014 to 2018. I probably don't emphasize that enough, except that I want to be careful everybody remembers that doesn't mean that we've gone over to a lender control system. That's not true. What we've gone to is a system which is a lot of lender control, and we should be able to understand the extent to which that's a good thing and the extent to which that might be a bad thing. But there's an awful lot left to do.
Professor Lienau.
Thank you. So like Jared, I thought there were a bunch of good questions in the Q&A, and I don't want to be too long, but I was interested because listening to you reading the paper, it did seem like, well, it seems like when somehow we have to have the preservation of liens in bankruptcy without the further empowerment that the liens give you in bankruptcy. And so I was wondering about, you talked about sort of the look back, clawback provisions. I wonder if you could talk a little bit more about that, right? What could that look like in a way that might help the situation? Because it seems like that strikes me as right, and I want to hear more.
Well, that's a great question. And I'd love to hear your thoughts as they mature on that subject. One thing that I think is where we start, which actually is interesting, is where you start on the sovereign debt side, and that is with transparency. There is Article 9 is dedicated to non-transparency, right? All you got to know is that I'm here. Call me, and I'll tell you all about it. That's the Article 9 system. And so as a result, maybe what we need in the bankruptcy context, where we have a different set of concerns, is a transparent disclosure of everything that went on in connection with a controlled transaction. Now we can have a discussion of what is a controlled transaction, but I would argue, let's say anything more than a 50, 60% secured debt in comparison to assets looks to me like a transaction that gives an awful lot, and a lot of control, if not complete control, to the lenders. Maybe there should be a disclosure of that filed in connection with the case. Maybe there should be discovery readily available on that point. I haven't thought that all the way through by any means, but I think that's the kind of thing that would help a lot. It might also, if it's true that bribes are being paid to management, so to speak, in the form of golden parachutes, in the form of guarantees of stock ownership in an emerging company, or whatever, then we ought to know that, and it would be very helpful to everyone concerned, starting with the court, to know those things. So I guess transparency is where I would start with that. And if we find that there really is a problem, and that, on balance, when we look at the benefits of lenders getting security, then versus these concerns, then we could have a better idea of what kind of bankruptcy solution, like a clawback or whatever, or a restriction on debtors, on lenders' rights, would make sense. But it's a great question, and I'm glad you're interested in it.
Seeing no other hands, I'll move now to the Q&A by the attendees. Beginning with a comment. It would be interesting to know how many DIP lenders are the existing secured lender. In that situation, the DIP lender is effectively financing the liquidation of its assets.
The one thing that's interesting, which we've not yet been able to quantify, is the question of how often is the lender the DIP lender. And that turns out to be harder to figure out than you might think it is. And so we did a first pass on the data, and we got numbers that are confused and ambiguous. And we're going to have to go back and take a further look and get the answer to that. My instinct is that the pre-existing lender is routinely the DIP lender. And that's a lot of the problem with non-competitiveness in the DIP lending process. But I can't prove that as of now.
The next comment was regarding, I believe, to a comment you made in response to a question, which is, once again, the golden rule is operating. The lender with the gold makes the rules.
Can't argue with that. But we do have systems in place that say, well, wait a minute, the rules have to be within some limits.
The next question is on methods. The questioner asks, how does your study determine loss of value, and is it quantified?
Yeah, and the short answer is no, you don't do either one. All we have done is say, in the public company context, we're convinced that these two articles show a loss of value where these indicia, particularly DIP agreements, milestones, and roll-ups, where those are present, there's the public company analyses suggest there's a loss of value. We haven't got the data that you have for public companies to fully pursue whether or not it produces that same loss of value. But I guess what we're saying is, well, we're seeing the same critters in a widespread group of cases, and therefore we suspect that there's the same or similar loss of value. And that's as far as we can go as of now.
Another comment from the attendees is that one hypothesis to explain what management is able to retain control is that those who retain control have the ability to operate cash collateral.
Yes, absolutely. And cash collateral is an incredibly important part of control. If I'm a pre-existing lender and I have a security interest in substantially all of the assets of the company, then the company has access to more or less no cash whatsoever, unless it can do something like this brilliant move by Hertz to go out and sell all of this post-petition stock, which is so remarkable. What a world we live in. And now, of course, to be talking about a plan that would make that stock worth exactly nothing only a few months later, that's a whole new world.
The next question from the chat is, will the availability of subchapter 5 have any effect on your paper and on its findings?
Oh, absolutely. If we do another study, a year from now, even in these two districts, which have so many large cases, they also have lots of smaller cases. In particular, New York has lots of smaller cases. So I guess I would expect to see much less impact in Delaware, where the overwhelming majority of cases are group cases, and they're larger cases, significantly larger than in New York. Whereas in New York, there are a lot of companies that actually live in New York and run their business in New York, and therefore are standalone companies or maybe just one or two affiliates, something like that. I would expect subchapter 7 to have a huge impact in New York. So we might very well want to treat them as a separate subsample, so to speak, going forward.
A commenter remarked in response to your and Professor Lienau's discussion of perhaps when is the best time to evaluate when someone takes control of the bankruptcy case.
Yes.
Someone noted, it's not the power of the liens, it's the control of cash. Another question is whether the study differentiates between an underwater lender and one where there's equity in the asset. If the lender is underwater, unsecured creditors don't get anything anyway.
Well, they don't get anything anyway unless the company successfully reorganizes, right? And if the company can reorganize, then they do get something. So, and there are a fair number of companies that a couple studies have shown. I think Steve Lovin, for example, did a study that shows that in Chapter 11, unsecured creditors do get paid in a minority of cases, but they do get paid. Now, whether or not that Steve's data, I think, go back to what? Maybe even pre-Great Recession. I don't remember exactly when he did that study. So I don't know if that's still true or not. Recoveries are very tricky things to deal with in Chapter 11. And it's important, too, for everybody to realize that lender control and these quick solutions are so pervasive that people talk about a free fall bankruptcy. And a free fall bankruptcy, a free fall Chapter 11 means any Chapter 11 where it isn't all settled before the petition is filed, except for the need to use legal coercion to make the results stick, right? So to the extent that that sort of thing is true, it really it's going to make it more difficult going forward for all of us to evaluate these cases. That's why part of my talk in response to Odette, part of my talk about transparency is very selfish, the very selfish position of an empirical researcher who needs this information. Isn't sure how else to get it.
A commenter asked a follow-up question to one earlier in the queue, which is, how do you determine loss of value? Is the value loss suffered by the lender?
No. The argument is, in these two papers, I mean, there are all kinds of possible losses of value one way or another. For example, the basic decision to sell the company at X price, or to try to continue the company with possibly a larger upside. But putting all those possible losses of value aside, the two articles on which I'm relying in writing this paper comparing our data. Those two articles are talking primarily about the costs of DIP financing and the cost of simply running the process in a way that benefits lenders primarily. That's the loss of value that they're talking about. And they measure that primarily by the effects on the financing process. And I commend the articles, by the way. Go look at them. They're really good.
Professor Brubaker asks, is there a good reason to believe that the availability of roll-ups and other devices gives existing lenders a systematic advantage or incentive to provide the DIP financing that squelches competition in providing DIP financing from new lenders?
I think the short answer is many people have assumed, and I think all three of these authors have assumed, that that would be the case. But Fred Tung in particular argues that that is not a good explanation. Actually, I guess all three authors ultimately conclude that DIP loans seem to be on a basis of higher interest rates and more onerous terms than one would expect, given the fact that they are on the whole really safe. They have an enormous amount of legal punch behind them and put the lenders in a position of very close scrutiny and control over what goes on in the Chapter 11. And of course, they sometimes include Christmas presents like no one who gets a carve out can contest the validity of the lien. Wow, that's pretty terrific. So, well, to make a long story short, I think that's all I can say about that.
There are two remaining comments from the chat. The first one reads, cash collateral is the key to the kingdom. A debtor who is losing money cannot possibly provide adequate protection for an asset-based lender.
I think in general, that's true. Absolutely. Unless you can find a competing lender, right? And unless you can refinance your debt at least in part, from another lender. So yeah, I mean, I think that's a true statement, and that's the source of the lending, the pre-bankruptcy lender's control, especially when their position is secured. There have been a couple striking cases, and I'm going to have to go back and look and remember which ones they are recently, in which there was competition for the DIP lending, but indeed what we found was that there were the lending group was unsecured or substantially undersecured prior to bankruptcy. So yeah, that makes a huge difference, because there's no question a dominant security interest leads to a control of cash collateral under Section 363. And once that is true, then the lender is in a very powerful position to dictate terms, and other lenders are going to be very reluctant to lend into over the objection of the pre-petitioning lender, to lend into that legal, how shall I put it, legal fortress that is a thoroughly secured pre-petition lender.
I'll come back to the comment because another question just arose, and I believe it's based off what you just noted,
okay.
Which is how do you refinance your debt when you can't operate because you don't have cash? And how I read this is there's no cash collateral.
Well, Ken and Jared have suggested an interim solution, and Jared would speak better to this than I can. But they put in their paper the idea that maybe there could be a temporary DIP loan. I mean, you do see some of that in the cases where the orders don't take effect for a while. But I take it they want to go farther and say there could be a temporary DIP loan that must provide enough cash to operate until you have a chance to have competitive bidding for DIP lending for the rest of the case. I don't know whether that works or not, but I think it's responsive to that kind of concern. How can we do anything about this as long as this is the only source of funding? And isn't it interesting that we've gotten back, as someone said, we've gotten back to whoever has the money makes the rules. On the other hand, the idea, which maybe now is out of date or doesn't work anymore, the idea of Chapter 11 was precisely that we don't let any creditor group do that. put in the automatic stay, we bring everything to a screeching halt, and we make sure that the court has some opportunity to make sure that people are fairly treated. And it may be that the existence of pre-petition security interests that leave no assets available and no method to realistically prime pre-existing lending. And of course, 364D purports to grant the possibility of a priming loan for post-petition financing. But it seems to be very underused, and one can understand why competing lenders would be very hesitant to walk into a situation where they had to try to get a priming lien and feel able to rely on the fact that it was going to make them superior to the pre-existing lien. I think there's a serious question as to whether dominant security interests are consistent with the purposes of Chapter 11 for just that reason, the difficulty of refinance.
Continuing with comments in the chat. Someone noted that in most of the cases that I see, outside DIP financing is not possible because of the asset and debt ratio.
Mm-hmm. Okay. That's a good general comment. I'm not sure what to do with it. We had for a very long time, we had a system in which many companies went into bankruptcy without having given blanket liens to their creditors. And those companies, many of those companies were successful in the 70s, certainly, and even, in the 80s, certainly, and even into the 90s, were successful in getting DIP finance. So from that, I conclude that if we had rules that produce some limits for pre-petition secured credit lending, then there would be a possibility, notwithstanding substantial debt, there would be a possibility for post-petition lending as well.
There's a greater discussion going on in the chat, sort of regarding a new DIP lender versus a roll-up DIP lender.
Yes.
And I'll just sort of read the various comments and questions that have come about on this topic,
Okay.
and permit you to respond. So
yeah, I'm just pleased that people care.
the first question asked in this chain was okay. So someone recommended earlier that a new lender could potentially take out the existing lender as a matter of priority. And then someone else noted the temporary lender will want to be in the first place. How do you provide adequate protection to that existing lender? Professor Brubaker then asks, the goodwill value of the company should be considered unencumbered by pre-petition liens on the petition date, shouldn't they? And then the final comment that was made is that there's no priming because there's no possibility of adequate protection to the lender. And I'm not sure which lender they're referencing there.
Yeah, I'm not sure what the last comment means, which may just be my inability to pick up on it. It seems to me that if you had a lender, and again, you often did in the 80s, when if the dominant question was why, it's just terrible the way these debtors are getting away with murder in Chapter 11. And that was in a context in which they frequently had primarily unsecured debt, and they were able to get DIP financing on terms that permitted management to considerable flexibility. So my short answer is, if we had some method of either preventing or regulating or whatever pre-petition dominant security interests, and that, whether or not that's a good idea, certainly subject to debate and consideration. But if we did, then I think there would be an opportunity to offer liens to post-petition lenders that would make them that would make it attractive to lend to a debtor, as it used to be.
I'll raise back the question Professor Brubaker posed, just because there's been a subsequent question in the chat about it. Professor Brubaker, I'll remind you, noted or asked rather, the goodwill value of the company should be considered unencumbered by pre-petition liens on the petition date, shouldn't they? And then Judge Bonnetfeld asks in the chat, what if the security interest covers goodwill? Does the UCC permit the lender to take a security interest in that?
That's a really interesting question. And I've seen people argue each side of that one. I don't know if Ralph is thinking primarily of going concern value when he says goodwill. If that's what it is, there are the two outstanding articles by Jacoby and Janger that address that very question of the reorganization value and whether or not the secured lender has an interest in the reorganization value. And they argue strongly that it does not. On the other hand, it's not entirely clear drawn. If you take their argument seriously and you say, yeah, that's right. On the other hand, what does that mean for a post-petition lender? What can you offer to the post-petition lender that equals the reorganization value? So it doesn't necessarily solve the problem we're immediately talking about.
And one last, I was just informed by one of the panelists that it was accidentally answered. Mark Dudall writes, the challenge I have to this is the consideration of the downside risk. Some Chapter 11s, even some very large ones, go spectacularly wrong. I'm talking about cases where the sale or plan goes completely off the rails such that the DIP loan cannot even be repaid. That risk, no matter how slight, of a complete goose egg warrants many of the expanded economics and control rights that might otherwise be shocking. Remember, when a lender puts in new, such as DIP, money to save an investment, and not only is the old money lost, but the new money is not repaid. In those instances, those workout officers can and do lose their jobs.
Yeah, right, absolutely. Can't argue with any of that except to say my sense of the history is that if you don't have dominant security interests before bankruptcy, there is an available path for people to make post-petition loans.
I'll note one last question that did appear from Judge Bonnetfeld. He asks, and who's going to lend on post-petition? He had a case where the debtor valued its trademark at $50 million. The company sold for $18 million. And it ended up selling to the lender whose debt was over $50 million.
Right. Valuation is the death of us all.
Well, Professor Westbrook, I thank you very much for taking an extended time to sit on the hot seat.
Well, at least I made everybody mad. I mean,
I also thank all the attendees for their questions. It is and comments. It is greatly appreciated. With that, I will issue some very short closing remarks. I'd like to first and foremost thank the panelists for your time, for your thoughts, and for your thought-provoking pieces for today. I would be shocked if anyone was able to attend this workshop at any point through the day and not be able to pick up something new and learn indeed from all of you all. So thank you for that. I thank the attendees for coming, for participating and asking questions and furthering in what was a great discussion. I'll make a couple perspective notes. So first off, while this workshop served as an excellent event and one where many questions were able to be answered and others raised, this is culminating in a special issue publication that volume 37 of the Emory Bankruptcy Developments Journal will be publishing later on this spring or early summer. And we hope as many of you who were able to attend today will read that publication. And then finally, I was requested to make a note about CLE credits for folks who are seeking CLEs for both Georgia and out-of-state individuals seeking CLEs. If you have any questions, please feel free to reach out to myself or Vera Bespalova, who should be on some sort of an email that you've received to this point, and we will happily help you in getting your CLE credit and getting accredited if you're seeking it from out of state. Again, I thank everyone so much for taking the time, and I wish you all a great afternoon. Thank you.